Well, I'm very glad to see this stalwart group of people for the last panel of the afternoon. And our discussion is going to take us from the world of states and state regulation and state laws and the rest to private law, which is only appropriate given the location. And since other people have told their stories about their acquaintance with Justice Scalia, I am going to suggest to you that I'm probably the only person here for whom 3 of Nino's children babysat for my children over the years when he was my colleague at the University of Chicago and thereafter. So long and fond memories there. So our topic, as listed in the program, is private international law. It's going to include both the ways that courts may become involved in this area of the law and the big giant in the room, arbitration of various kinds. And we have an exceptionally well-qualified panel, once again, to lead us in this discussion. We're going to start with Peter B. Rutledge, known as Bo to his friends, who is the Dean of the University of Georgia School of Law and an expert in international litigation. In fact, the co-author of a book that has been a leading book in this field for years, with Gary Bourne. He's familiar with all aspects of these things, and he's going to lay the stage for us. We will then move to Jessica Chrostin, who is a partner at King & Spalding, and her practice focuses on complex international dispute resolution, once again, of all types: commercial, investor, state, mining, construction, renewable energy, and it seems anything else you can think of. So she is going to pick up from there. And finally, immediately to my left is Hilary Heilbron, who's King's Counsel, no longer Queen's Counsel, King's Counsel at the Brick Court Chambers. And her focus, too, is on international arbitration, which she has done very many of all over the world, all different laws. And so it is my pleasure to turn the floor over to Bo.
Thank you, Judge, and thank you all for the opportunity to be here. I will begin with sort of 2 confessions. Confession 1 is I live in mortal fear of PowerPoints. I have PTSD from a presentation I made several years ago at the headquarters, ironically, of a European technology company, and I thought it would be a good idea to bring a PowerPoint. And hell hath no fury like an American PowerPoint at a European technology company. It took more time to repair their system than it did to present the paper. But I'm convinced that if Michael Grieva, Judge Wood, and Gary Bourne are in the room, all is going to go well. That's confession 1. Confession 2, picking up off of a comment that was made at the first program this morning, I'll ask a philosophical indulgence, and the philosophical indulgence is with a reason. And that is, why should we care? Having heard what we've heard from the 3 prior panels, why should we care about the private law of nations? And so my second confession, if you haven't read it, is to encourage all of you to pick up Immanuel Kant's essay of Perpetual Peace. And if you read it, Kant talks in memorable terms about the pathway to peace among nations being commercial relations, or what his term was at the time, intercourse. And his point basically was the insight that nations that sort of build robust commercial relationships tend to find a way to get along. Now, that hypothesis can obviously be overstretched, but the reason why I sort of bring that philosophical point of information to the room is as follows. The reason why I think we should care about the private law of nations is because I think at bottom, the private law of nations and some of the topics that we'll be talking about are at bottom the architecture, the test whereby we decide whether or not these commercial relations will be sustained. And so my goal today is to sort of walk you to bring another law and economics forum topic into the room, walk you into the law market. My first participation in one of these programs was actually when Larry Ribstein and Aaron O'Hara's book on the topic was introduced. And if there's sort of a punchline to my presentation, it is don't forget federalism. So to start, I'm going to start by talking about international litigation and federalism, and then pivot to international arbitration and federalism. Now, these are, in some sense, nothing more and nothing less than 2 products on the law market. At the end of the day, since the rise of robustly enforceable forum selection our arbitration and as well choice of law clauses, whether commercial actors, particularly transboundary sophisticated ones that are working in and across markets, decide where and how to resolve their disputes, and just as importantly, the architecture in which they'll contractually decide how to resolve their disputes at the time they're closing the transaction is so important. Beginning with litigation, and this is, I didn't do the PowerPoint slide so that you could see this fancy little image, but rather because I think the point about my observation about federalism is ironically, at least in the United States, the incredible patchwork of laws that govern things that, particularly for Europeans in the room, would stun you to think that there's not sort of a national rule on this matter, notwithstanding the fact that for over 200 years we've had sort of an unquestioned foreign commerce clause that was one of the true parts of our evolution from the Articles of Confederation to the US Constitution. So starting with the simple concept, Judge Wood and I were talking about this earlier, personal jurisdiction, or what you might refer to as judicial jurisdiction, right? We normally might pick up European Directive 44/2001, or its more recent successor 1215/2012. And we might sort of say, between that and looking at the laws governing judicial jurisdiction in France, Germany, the constituent states, here's how we figure out whether or not the courts in those states can exercise power. Not so in the United States. By and large, the ability of any U.S. court, whether state or federal, to assert its power in a foreign commercial dispute is largely, though not exclusively, the product of state law. Now, that state law is not completely divorced from federal law. For those of you who are my American lawyers in the room, you're going to know that some states will have essentially authorized jurisdiction to the limits permitted by the Due Process Clause. We may ask ourselves after the Supreme Court's decision in Mallory exactly what those limits are and whether or not the quote-unquote Dormant Commerce Clause has some sort of second life to sort of serve as a restraint on state exercises of personal jurisdiction. But you see from this simple graphic the variation, if whether or not you're representing a U.S. company against a foreign company or vice versa, the uncertainty about where exactly you can sort of invoke the power of that court to render a binding enforceable judgment against the defendant. To take it one step further, if we sort of step back to Civil Procedure 101, we'll understand that there's sort of historical differences between general jurisdiction, that is jurisdiction irrespective of its relatedness between the defendant's contacts with the forum and the claim, and specific jurisdiction that requires that degree of relatedness the Supreme Court talked about in its recent decision in Ford. Now, what's noteworthy here with respect to the private law of nations and the role of federalism is two things, one under general jurisdiction and one under specific jurisdiction. Under general jurisdiction, recognize the fact that as a result of the Supreme Court's recent decision in Mallory, it's now entirely possible for a state to condition the registration of doing business in that state, including a foreign corporation's registration of doing business, to wholesale consent to any jurisdiction over any claim against that corporation, even if those claims have absolutely nothing to do whatsoever with that corporation's contacts with the state. In other words, you can be a German company who decides you want to sort of enter the market in Pennsylvania. In order to do so, you register to do business in Pennsylvania. And now, as a result of the Pennsylvania statute that was upheld in Mallory, you are now subject to the general jurisdiction of Pennsylvania courts, even for claims that have absolutely nothing to do with your contacts with Pennsylvania. That's the first significant impact of the role of state law here on the private law of nations. That is, wow, 5 already. The relationship between doing business and personal jurisdiction. Second point, specific jurisdiction. We talk ad nauseum about sort of the role of context of the forum. Often overlooked, but no less important, is the way that the forum is defined. Although the Supreme Court's never come out and addressed it, the forum could as well be the full panoply of the United States, and in other cases, it could be a particular state, Georgia, Virginia, et cetera. Whether or not it is depends critically on the claim that's being brought, a federal claim in a statute that has a nationwide or worldwide service of process provision would, under certain appellate case law, allow the entire U.S. to serve as the relevant forum for purposes of aggregating contacts. By contrast, a tort claim, a contract claim, your garden variety quote-unquote common law claims, even if the federal court's sitting in diversity, that federal court has to analyze the context solely by virtue of the forum state in which it sits. Personal jurisdiction. Recognition and enforcement of foreign judgments. Again, my Europeanists in the room, you'll be familiar with the Brussels and Lugano conventions, the European directives that sort of followed it. Far different world in the United States, right? notwithstanding the fact that we heard all of our economists and our political scientists talk about the robust role of the U.S. economy, remarkable, isn't it, that we're not a party to a single, certainly haven't ratified a single bilateral, multilateral convention governing a judgment enforcement, and notwithstanding the good offices of the American Law Institute, we don't have a federal statute that governs the enforcement of judgment. Instead, it's an entire hodgepodge of sort of federal common law traceable to a late 19th century Supreme Court decision that since the Supreme Court's decision in Erie has largely been reduced to questions of state law. Ironically, even in situations in which the federal court is sitting to decide whether or not to enforce the foreign judgment, because under the Erie doctrine, the federal court sitting in diversity, applying sort of state substantive law, the predominant view, exemplified by a well-known federal decision called Somportex, is that that federal court has to apply state law in deciding whether or not to give effect to the foreign judgment. And even in deciding whether or not that foreign judgment violates public policy, you're looking at the public policy of the foreign state, not some federal public policy. You see here, much like with personal jurisdiction, a patchwork of views on whether or not foreign judgments will be enforced. Again, remarkable that in 2024, the most economically important nation in the world, at least right now, can't seem to sort of agree to any degree of harmonization on something as simple as foreign judgment enforcement. And you see how sort of episodic it's been. There's been no sort of meaningful process of aggregating any kind of uniformity in foreign judgment enforcement. Now, it's not limitless. We have a few sort of federal laws that fill in the gaps. For example, a federal law that governs the enforcement of foreign libel judgments. We have a couple of constitutional limitations, foreign affairs preemption, foreign commerce preemption, slightly more nuanced version under the tonnage clause as a result of a case called Polar Tankers that Chief Justice Roberts handed down a little over a decade ago. And although we have really good treaties that the United States has signed, it has neither ratified the Choice of Courts Convention nor the more recent Jurisdiction and Judgments Convention. Again, the punchline here, remember the states. Pause. Let's switch to arbitration. Now, remember, two different pieces of the law market, litigation, arbitration. How different the world looks. The U.S. is part of the New York Convention, it's part of the Panama Convention, it's part of ICSID. So we have, by contrast, a much more robust infrastructure, not unlike what you would see in other parts of the world. What's odd, though, is even under the architecture of U.S. international arbitration law are the massive gaps, right? So the U.S., unlike a lot of European nations, a lot of Asian nations, has not adapted an international arbitration law. To the extent there's an international arbitration law in the United States, it's basically the implementing legislation of the main conventions, the Washington Convention, the Panama Convention, the New York Convention. As a result, again, you see states sort of filling in the gaps. They may do so through adopting the UNSTRA model law by the state. They may have their own Uniform Arbitration Act, more recently the revised Uniform Arbitration Act. So here too, again, why the PowerPoint slides, you see this familiar pattern. To the extent you are a Europeanist, you're an Asianist, you're deciding to what extent do I want to do business, to what extent do I have to think about the dispute resolution infrastructure that's the pathway to intercourse and commercial relations. I can't just sort of pick up the regulation. I can't just pick up the treaty. Even to the extent I pick up the New York Convention, I have to look at the fact that there are nearly 10 states that have their own international arbitration code that is in no meaningful respect preempted by federal law. Where does this matter? Two examples, and then I'll close. Example one, we saw, for example, in Belgium in the 1990s, a desire to sort of contractually modify the grounds for judicial review of arbitration awards. It took on a brief vogue status in the United States until the Supreme Court shut it down in a case called Hall Street. But the Supreme Court said, interestingly, while federal law doesn't allow parties to modify the grounds for judicial review or an arbitration award, nothing precludes the parties from invoking remedies that may be available under state law. And so not long thereafter, both Texas and California said, absolutely, if you want to modify the grounds for review of arbitral awards in our states will enforce that contractual modification. The other example, pre-award attachment of assets. This is oftentimes, particularly in large commercial cases, less so in large sovereign cases, the name of the game. To what extent can you sort of put a judicial hold on the property before the arbitration has ever been commenced? There's been a great deal of disagreement among the federal courts as to the availability of that remedy. Not so in the states. New York, in a well-known case called Sojitz, reaffirmed the ability under New York law for New York courts to freeze arbitral assets in support of an international arbitration that's never been commenced. Perhaps even more interestingly, in Connecticut, in the Bahrain telecommunications case, a federal court in Connecticut said, Even though the arbitration is not cited in Connecticut, even though there's not a federal law on the subject, we'll invoke Connecticut's international arbitration law to freeze these, to at least conclude that we have jurisdiction to freeze these assets. Again, step back from the legal landscape for a second. Look at this through a European or Asian lens. The idea that a region in Lower Austria could ever decide whether or not somebody's assets could be freezed as a result of a transboundary commercial dispute would cause us to run through a wall over here. But this is part and parcel of this sort of fabric of federalism that we live and breathe every day. Oregon, Texas, very similar. California as well. Thank you very much.
Thank you, Bo. All right, Jessica, let's move on to you.
Thank you. Before I start, I had some PowerPoint slides. I wonder if there's the opportunity. Ah, okay, perfect. Thank you. Okay, so I'll be talking about a topic that's adjacent to what Bo was discussing, or rather a subtopic of arbitration. And I'd like to start off by asking how many people in the room would consider themselves investor-state arbitration experts or savants? Okay, how many people in the room have heard of the concept of investor-state arbitration? Okay, so we have some background here. So the reason I think investor-state arbitration is a fascinating topic, and honestly one that really challenges our notions, our traditional notions of what sovereignty means, is that it's a method of public-private dispute resolution that really occurs outside of the bounds of a host state's justice system. So let me start first with an overview of the origins of investor-state arbitration. So it really, as I just mentioned, is a type of mixed arbitration. It's arbitration brought by a private party, most common that's a company, but it can also be an individual, a natural person, against a government, against a state. Historically, as many people in the room probably know, so I won't belabor the point, if an individual wanted to invoke protections against a government, it needed the protection of its own home state. It needed to invoke some form of diplomatic protection or persuade its home state that it was appropriate, necessary to initiate proceedings against a foreign government. And so you would end up with intra-state disputes on behalf of individuals or companies. Now, the first example that we have of the type of mixed arbitration that I'm talking about today arose in 1935. It was a case that was brought by a company called Radio Corporation against the government of China. And in that case, the company sought to bring the claim under the Permanent Court of Arbitration, which was established roughly 40 years earlier for intrastate disputes. But the PCA found that it did have jurisdiction to be the administering authority for this public-private dispute resolution process. Now, only after World War II does this really lead to a proliferation of disputes, and I'll come to a slide later on that shows really we see an uptick only in the 1990s. So it took a long time for this type of dispute resolution to really gain traction. But a good step in the right direction came in 1965 with ICSID, the International Center for the Settlement of Investment Disputes, which Bo made reference to earlier. And one of the remarkable things about ICSID is that the contracting states, of which there are over 150 today, all agreed that arbitration awards rendered under the auspices of ICSID are to be treated by states as if they were judgments of that state. So it's much easier to enforce than a foreign judgment in most instances. And then, of course, in 1976, we have the first iteration of the UNCITRAL rules, which are a set of procedural arbitral rules that parties can invoke to govern their arbitrations. So with that history, let's get to what investor-state arbitration actually is. So in a nutshell, it's a lawsuit, like most others that you would see, and it's conducted very much like a lawsuit, but it is brought by a private party against a government when the private party's investment in that host state of the investment has been harmed by government conduct. So this must be related to a violation of an international treaty. For the most part, that will be a bilateral investment treaty or a multilateral investment treaty, such as a free trade agreement. And it must be a violation by virtue of conduct of the government. So not by conduct of private third parties, although there is a small carve-out, which I'll discuss later. Nowadays, we have more than 2,500 investment treaties that are currently in force across the world. So you can see that really there is a very broad basis to invoke these types of protections, provided you are a qualified protected investor under those treaties, or at least one of them. So another aspect that makes this a particularly interesting form of dispute resolution, and one of the reasons it was originally designed, is to avoid having to go to the host state that did the harm to your investment to have your dispute resolved by the courts of that host state. You can see where there might be a conflict of interest. So instead, in investor-state arbitration, you can bring your claim in front of private individuals, the arbitrators. And most commonly in investor-state arbitration, that will be a panel of 3 arbitrators. Usually, one is appointed by the investor, a second is appointed by the opposing state, and the third is appointed by agreement of the arbitrators or agreement of the parties, or sometimes by the appointment of ICSID or the PCA, for example. And the governing law of these types of claims is international law. So another thing that makes this such a unique form of dispute resolution is it's one of the very few fora in the world where you can say customary international law governs my particular investment dispute. So the primary law that applies is the law of the treaty you're invoking, and the secondary law that applies is customary international law for the most part. And so this is the slide I mentioned earlier that shows the proliferation of case law, and you can really see a significant rise. It's almost a straight line until, I'd say, around 2017. And the first example was in 1987, but then you have from 1993 onwards a steady rise, as I mentioned. And there were almost 90 cases filed in 2018, which was the highest number in history. But there still are a significant number of cases being filed virtually every week, mostly with ICSID, but also a lot under ad hoc arbitration under UNCITRAL. So the types of protections you can invoke are usually set forth in the treaty itself. Some of these concepts are more nebulous than others. So one of the primary protections is called fair and equitable treatment, or FET. What does that mean? We're still trying to figure it out. Now, the thing in international investor-state arbitration is there is no binding precedent. So you can't say, well, this tribunal in 2004 held that FET means X, therefore FET must mean X under my dispute in my treaty. Instead, each time a tribunal is faced with questions of fair and equitable treatment, they have to de novo interpret the language of the treaty that they're applying to figure out what fair and equitable treatment means in that particular treaty. Now, of course, tribunals are often persuaded by prior case law, but it's not binding on them, as I mentioned. So there's a lot of flexibility, and you need to be very careful in deciding who you want to have as your arbitrator, because the qualifications of your arbitrators will be directly corresponding to the quality of the award that comes out at the end. So the second most commonly invoked protection is expropriation. So as you probably know, in many countries around the world, expropriation can be done lawfully, but usually there are restrictions, such as it must be done in accordance with due process of law. It must be against compensation. So you can't undo the expropriation necessarily, but you can get compensation for it. Another frequently invoked protection is the so-called umbrella clause. It acts as an umbrella to bring under the scope of the arbitration other kinds of protections that you may have, for example, under an investment agreement with the host state of your investment. There's also most favored nation treatment, which I think speaks for itself. One that I'll pause on for a second because I think it's interesting since it goes to the issue I mentioned earlier of whether it has to be a government act that breaches the treaty, and that is full protection and security, or FPS. So there in recent years, there's been an expansion. It started off as a protection that really applied only to the physical protection of investments. But in recent years, there's been more and more arbitral authority in favor of finding that it can also encompass legal protections. When we're talking about physical protection, it's quite clear to see what could be encompassed within that scope. And private third-party adverse conduct towards your investment is also covered because the government is found to have a duty to protect your investment physically. So I'll give you one example. It's a famous case against the government of Egypt, Wiener Hotels, where private third-party individuals physically took over the hotel compounds of the investor, destroyed the hotels, and then eventually left. It was found to be a breach of the FPS protection in the applicable treaty that the government did not step in and physically protect the hotels. So that is the one small carve-out where the acts of private investors can eventually lead to government responsibility under an international treaty. So this here I'll do very briefly. It's just an example of a typical dispute resolution provision in one of these bilateral investment treaties. This one is from the Dutch Model BIT from 2019. It sets forth in the first paragraph, you see that there is a sort of pre-arbitration negotiation requirement. Many treaties have those nowadays, and there's a lot of case law on whether that's a procedural requirement or a jurisdictional prerequisite, which I won't bore you with now. But then once that prerequisite is satisfied, the investor gets the choice usually of where they want to file for arbitration. So this particular model BIT allows the investor to pick between ICSID or the UNCITRAL rules. So how does investment arbitration work in practice? Well, as I said at the outset, very much like a regular trial, like a regular litigation, except that a lot more is done in writing. Okay, so to begin with, the investor usually needs to satisfy the jurisdictional requirements. Now, a prima facie satisfaction sort of suffices for that initial step. If the government then challenges jurisdiction, there can sometimes be bifurcated proceedings just on the jurisdiction of the tribunal, or sometimes that proceeding is weaved in with the merits and the damages claims, and everything is heard at once. So you need to establish that you're a protected investor, which means that you have to satisfy the definition of investor under the treaty. You need to establish that you have a qualified or a protected investment. You need to show that your claims arose at a point in time that is protected by the treaty. So for example, some treaties are only effective as of the date of their adoption, whereas others actually have retroactive effect as well. And then you have to satisfy any other obligations that are set forth in the treaty. Then you get to appoint your tribunal. So you get to pick who your arbitrator is. That means a lot of due diligence on who your potential candidates are. And then there's written briefings, usually 2 rounds. Now, the unfortunate part of investor-state dispute resolution is there is no such thing as a page limit. So I have actually had a case where the opposing counsel representing a state submitted a 1,100-page long brief, not including witness statements and expert reports. 1,100 pages. And then you have a hearing on the merits, on damages, and then at the end you get a binding award. And as I said, these awards are oftentimes easier to enforce than foreign judgments. Now, coming to my last slide, and I think the one that maybe will spur some discussion later on, some common criticisms of the system, and many of these might be evident from the way the system is set up, as I've just discussed it. So the first one is a lot of skepticism about private individuals deciding huge cases that can literally, quite literally, impact the GDP of a country. One of the largest examples, if not the largest, is the UCOS award against Russia, which was a damages award for over $50 billion. As you can imagine, Russia is still fighting against the enforcement of that award, according to some for very good reason, but that's a separate discussion. Then, of course, there's also an issue about the lack of transparency. This is a state basically delegating some of its sovereignty to a private dispute resolution mechanism that can actually adjudicate the wrongfulness of the state's own conduct. And you have that being adjudicated by private individuals, and usually these proceedings are not open to the public. Now, there are exceptions. ICSID, for example, has recently adopted a new set of rules that allows for much more transparency, but still you need some degree of party consent. And oftentimes states or investors will oppose that for publicity reasons. Until they know what the outcome of the award is, they might not want the details of the award to be known in public. So there are many reasons why parties to the arbitration still oppose transparency. Then, of course, there's the idea of interference with sovereign rights. And one interesting aspect of investor-state arbitration is you can actually obtain interim measures against a government to stop the government from taking certain actions that could aggravate the dispute. So, for example, there have been instances where claims were initiated against governments, and then suddenly the government initiated a tax investigation against the investor, or the government found that actually the CEO of the local company probably committed some wrong that we previously ignored, but now we think he should go to jail for. So you can oftentimes get relief from the International Tribunal against the government pursuing what otherwise would fall into its regulatory or police powers. The next one is one I've already mentioned, so I'll just mention it again very briefly here, which is the fact that there's no binding precedent. There have been examples of treaties being interpreted differently, of parallel proceedings being initiated and one succeeding and one failing, even though they're technically speaking based on the same underlying facts. So there can be a certain risk of inconsistency there. And the last one is, well, I'll just say one that probably bothers me the most about the system, although I deal with it every day, is most often you have investments flowing from developed nations into developing nations. And as a result, when there are disputes, it's most often the developed nations' citizens or corporations initiating proceedings against developing nations. And so there is a very natural imbalance that you can see arise in which countries get sued more than others. I'll maybe leave it at that in the interest of time, although there are many other interesting parts that we could discuss. So,
Great, thank you so much. All right, so let's move then to Hilary, more about the law of arbitration.
Well, good afternoon, everyone. Sitting as I now do as an international arbitration in international commercial disputes, I'm going to discuss just one aspect of that in the time available in the context of international commercial disputes. But there is a considerable overlap between what you've just heard and what I'm going to discuss. In both investor-state and international commercial arbitration, you have binding awards. You usually have 3 arbitrators. Unfortunately, you usually have very long briefs, and there is no binding precedent. And perhaps rather different from what's been discussed during the day, I will not be looking at it from a European perspective, given that we now have Brexit, but I will be looking at it from an English perspective. And of course, London is one of the main seats for international arbitration. International arbitration is subject to various distinct governing laws. There are 3 of them which may arise in an arbitration. First, the law governing the arbitration agreement itself, which is what gives the tribunal its jurisdiction. Second, the law governing the arbitral procedure. And third, the law governing the substance of the dispute in the main or matrix contract. I'm going to discuss the first of these, namely the law governing the arbitration agreement. And an arbitration agreement is subject to a separate regime from the ordinary law of obligations under European law, or now by virtue of retaining Rome III under English law. And the principles regime, therefore, affecting arbitration remain the New York Convention relating to enforcement, of which you've just heard, with which over 150 countries have now signed up to, which makes enforcement one of the great attractions of international arbitration. And in the context of England, it's the 1996 English Arbitration Act. I should start by pointing out that the context of my talk depends upon what is called wash-up. It is a term used because of its cleaning analogy to cover the last few days before a dissolution of Parliament, such that any unfinished business is lost at dissolution, save for a few urgent and important bills. And there was on the stocks an arbitration bill which would have amended the Arbitration Act in England and would have largely resolved the problem I'm going to address, but unfortunately failed to get into the washing up bill when our Prime Minister announced the imminent election in the UK. So it remains to be seen whether it comes back on the legislative agenda in the next Parliament. But meanwhile, the law on this topic remains in a confused, complex, and unpredictable state. The determination of the law of the arbitration clause is absolutely critical, as it is that, as I said, which founds the tribunal's jurisdiction. Issues as to jurisdiction under English law, and more generally, in fact, must be raised by the participating party at the outset so that the tribunal can determine its own jurisdiction, called competens competens, and that's preserved in the English Act. Under English, if England is the seat of the arbitration, then in limited circumstances, an arbitration can be made to the court. And a court challenge can also be made after the arbitration has been concluded as to the tribunal's determination on jurisdiction, sometimes after an interim award, but usually after the final award under Section 67 of our Act. And this extends to a party who has played no part in the proceedings. It again can be raised at the enforcement stage when someone seeks to enforce under the New York Convention, and it can also be relevant right at the outset when someone seeks to stay court proceedings on the basis of an existing arbitration clause, or also in the context of anti-suit injunctions or interim measures. The problem arises where parties don't include an express choice of law in the arbitration agreement, which of course is an independent and separate contract from the main or matrix contract. The classic case is where the substantive contract is governed by one law and the law of the seat another. But the arbitration clause is silent on which law applies. And the issue becomes even more difficult when neither the arbitration clause nor the main clause express a specific law. Various rather unsatisfactory formulae have been suggested by the English courts. I'm just going to address two Supreme Court cases in the UK briefly, but they emphasize the tangles that the courts in England have currently got into, and then take you very briefly to the proposed legislative panacea. The first case is a case called Enker, I won't pronounce the rest of it because it's largely unpronounceable, against Chubb Insurance Company. It was a majority decision of the Supreme Court and was a case where neither the main contract nor the arbitration clause expressed a law to govern the respective contracts. The seat was London and hence the 1996 Arbitration Act. The case involved the application of English common law rules for resolving conflicts of law in relation to the interpretation or scope of the arbitration clause. This is not a validity case, which I'll come to in the context of enforcement. The case concerned a fire at a power plant in Russia owned by Enker as an assignees. Chubb Russia, the insurer, paid out under the insurance and therefore became subrogated to the claimant and claimed against one of the subcontractors involved in the construction. And Enker intervened as assignee and, of course, therefore became bound by the arbitration clause. There were also ongoing Russian proceedings brought by Chubb against Enker, and so Enker brought an anti-suit claim in London to stop those proceedings. The issue was which law governed the validity and scope of the arbitration clause to determine whether or not an anti-suit injunction should be granted. The main contract was determined to be governed by Russian law only impliedly because of its close connection with Russia. The court then, applying English common law rules for resolving conflicts of laws, summarized the key applicable principles to determine the law of the arbitration clause, where there's no law chosen expressly by the parties to govern this. And in turn, therefore, this raises the issue of the importance of the seat. And I'm going to take it from their summary, which will illustrate the difficulties we face now in English law. The governing law, they said, is the system of law with which the arbitration agreement is most closely connected. But there is an inference in such situations that a choice of governing law for the contract will generally apply to the arbitration agreement. However, that choice of law which you take from the main contract can be negated where there are additional factors and may in some circumstances imply that the arbitration clause was intended to be governed by the law of the seat. And one example is that there's a provision in the law of the seat which indicates that where an arbitration is subject to that law, it will also be treated as governed by that country's law. Another factor which will weigh in the balance is the existence of a serious risk that if the arbitration agreement is governed by the same law as the main contract, the arbitration clause would become ineffective. However, where the parties have chosen a seat of arbitration, this will generally be the law of the seat, even if it differs from the law applicable to the arbitrator's substantive contractual obligations. However, the validity of and scope of the arbitration agreement is governed by the law of the chosen seat of the arbitration, on the basis that that's the law with which the dispute resolution clause is most closely connected. In that case, they held that the arbitration agreement was governed by English law and granted an anti-suit injunction. As you can see, it's a bit of a minefield, and ENCA has been criticized considerably in England. The second case is a case called Kebabchi, which was a Lebanese company, against a company called Al-Hamazi Foodstuff. Kebabchi was an enforcement case, so this was under the New York Convention, and the question was therefore one of validity transposed into English law by Section 103 2B of our 1996 Act. And the relevant provision was that the recognition or enforcement of the award may be refused if the person against whom it invoked provides that the arbitration agreement was not valid under the law to which the parties subjecting it, or, failing any indication thereof, under the law of the country where the award was made. So it's a different test. The respondent who took part in the arbitration under protest maintained that it was not a party to the arbitration agreement and therefore not bound by the decision of the arbitrators. As in ENCA, the first question was to identify which system of law the English court should apply to consider whether or not there was an enforceable arbitration agreement, the issue being English law or French law. The dispute arose out of a franchise agreement, and in 2015, Kebabchi commenced proceedings against the franchisor, referring the matter to ICC arbitration for resolution. The main contract, the overall franchise agreement provided for English law as the governing law of the contract. The arbitration clause specified Paris as the seat of the arbitration, but there was no law specified in relation to governing as to the governing law of the arbitration agreement. The arbitral tribunal applied French law as the law of the seat of the arbitration to consider whether or not the respondent was bound by the arbitration agreements, and concluded that it was a party to the arbitration agreements. And so the issue before the Supreme Court was whether the parties had made an express choice of English law and not an implied choice of French law, as the tribunal had found, as governing their arbitration agreement. The English Supreme Court took the view that the principles in ENCA applied with equal force to the issue on enforcement where the question of validity arises, and concluded that a general choice of law clause in a main written contract containing an arbitration clause will normally be a sufficient indication of the law to which the party subjected the arbitration agreement, absent an express choice of law in relation to the arbitration agreement. It therefore deemed the wording of the main contract clear enough to conclude that by subjecting the whole contract to English law, the parties impliedly intended to extend that choice of law to the arbitration agreement. And there were also other issues addressed. In fact, the case didn't end there because annulment proceedings were simultaneously brought in Paris and the Cour de Cassation, which confirmed the long-standing French position on the law applicable to arbitration agreements, that faced with an express choice of Paris as the seat of the arbitration, even though where the contract was governed by English law, the substantive rules of French arbitration law meant that French law governed the validity, effectiveness, transfer, or extension of the arbitration clause. So Kebabchi leads a double life, valid at the seat, but unenforceable in England. The English laws, as I said, have been on the law governing the arbitration agreement, have been controversial, and they do show a wide gulf between other jurisdictions. For example, Singapore has recently followed the law of the seat route. The Law Commission, which is our body which considers reform to law and is a statutory body, after consultation recommended a presumption or default rule that the arbitration agreement is governed by the seat unless the parties agree otherwise. This clarifies the position while leaving the parties open to make a specific joint choice if they want to, and it gives the seat added importance. So the position is that our law on the issue is a bit in limbo. If the bill doesn't become law, there remains plenty of scope for conflicts issues. If it does, I still have no doubt clever counsel will find ways of getting round it. But few in the international arbitration world would have thought that the state of our law depended upon what was called wash-up.
Thank you very much, Hilary. I can't resist saying that you will see from time to time in U.S. Supreme Court decisions about arbitration comments to the effect that it's quick, inexpensive, and easy. And I'm not getting that impression from what Hilary just has outlined. It seems as though there are, in fact, plenty of opportunities for, let's say, intersections between the courts and the arbitral procedure. So as we have done, let me first invite the panel members, if anybody would like to add to what you said or pose a question to one of your fellow panel members. Do you have anything? No? All right, well, I have questions for all of you, actually. Bo, you went quickly over the Mallory decision. I would say, as somebody who spends a lot of time in civil procedure, that both general jurisdiction and specific jurisdiction in the U.S. courts has become more rather than less muddled over the years. And just so that everybody in the room knows about Mallory, it was a case where pretty much everything had happened to this man. He'd been exposed to asbestos, and he'd worked in Virginia, and he'd worked here and there. He lived for a little while in Pennsylvania, but virtually nothing happened in Pennsylvania of any interest. But, except one big thing, the Norfolk Southern Railway had gotten a license to do business in Pennsylvania, and one of the conditions on such a license was that you automatically agreed to be sued on any claim. The language is extremely broad. And so the court decides, well, any claim is any claim. You've consented to general jurisdiction, end of discussion. But I wonder, Bo, if you could speculate whether you think other states are likely to adopt Pennsylvania-type laws, or will they think that that's going to turn you into a nightmare jurisdiction for business? Or what's your prediction?
Sure, and I guess I should say in an abundance of caution, I should disclose, I filed a brief in Mallory, so the views that I'm opining here are my own. So at the time that Mallory was decided, there were only two states that had statutes like this: Pennsylvania, which is the one at issue, and Georgia had a slightly different one. And it certainly was the case that much of the briefing fretted that if this becomes the way to resuscitate broad conceptions of general jurisdiction after Daimler, that sort of the parade of horribles would follow. My sense is it has not, and I have a theory why. And I think the theory why is essentially in Justice Alito's opinion, because there's speculation that he may have actually lost the court in this case. If one sort of reads the Gorsuch opinion and the Alito opinion, Alito's opinion reads like it started as a majority and then ended up as a concurrence. And for those of you who haven't read this decision, it's unusual because you have 5 justices who decide that this sort of general jurisdiction by registration statute doesn't violate the Due Process Clause. You have 4 others who do. And one of the 5 who says it doesn't violate due process, namely Justice Alito, thinks that there's a serious concern whether or not it violates the Dormant Commerce Clause. And so my theory as to why Mallory has not led to the parade of horribles is you have this unusual alignment where I feel like the holding from Mallory is basically 5 justices conclude that the Due Process Clause does not invalidate a state statute that is still unconstitutional, right? Because you've got the 4 Mallory dissenters and you have Alito saying we should adopt Steve Sachs's theory about this should basically be a Dormant Commerce Clause issue as opposed to due process issue. That's why I think the parade of horribles hasn't happened. But I certainly agree with your broader point that judicial jurisdiction generally and general jurisdiction specifically has become more, not less, muddled. And I suspect, too, that what may well be the aftermath of Mallory is at some point, particularly if we look at the decisions that came down today, at some point, some sort of frontal attack on the shoe framework. That if you begin to just count the noses, we're kind of heading the way that folks sort of saw Chevron was heading as well.
So, and of course, the broader point being that if we're talking about the position of the United States in the rest of the world, all of those maps that you put up are a bit chilling. All right, so let me move on to Jessica and ask you, in this investor-state arbitration space, do you see the same kind of close interaction between the courts and the arbitral body as Hilary was describing? Or
Are we on the clock? I'll need 45 minutes, I think.
Do the best you can.
It's a tough question to answer for a few different reasons. There definitely is an intersection in which the courts and investor-state dispute resolution live together. You can, in some instances, get the assistance of courts, for example, for interim relief, where a interim relief order from the tribunal was not effective, because obviously a private tribunal doesn't have an execution arm. So sometimes you need to go to a court for a more effective remedy, or one that can be directly executed by the jurisdiction of the courts, police enforcement, et cetera. The next intersection, I think, comes really at the enforcement stage. And that's where it makes a real difference which procedural rules you subscribe to. So, for example, as I mentioned, ICSID arbitration, it's supposed to be enforceable like any judgment of a domestic court in the jurisdiction in which you're seeking enforcement, so long as that jurisdiction is a signatory to the ICSID Convention. Now, in the commercial context, you have the New York Convention, which was also mentioned during today's conversation. And the New York Convention would also, for the most part, be the convention that governs the enforcement of an UNCITRAL arbitration award. So that's an investor-state arbitration award, but it could also be subject to the commercial arbitration enforcement rules. So that's another area where you see a lot of investors needing courts' assistance. But in terms of the actual tribunals that adjudicate investor-state disputes interacting with courts, you don't really see that much, at least as a practical matter. What is also interesting is in investor-state arbitration, domestic laws are not considered law, they're considered facts. And so even there, what a domestic court does is not necessarily binding on the tribunal, because the tribunal is supposed to be sitting above a domestic court as an international dispute resolution body. It's one of the reasons you've seen a lot of tension in recent years between EU law and the existence of this dispute resolution system that really exists outside of the realm of sovereign states. But that's its whole own topic, so.
Yes, please.
I was just going to add, just to make it clear, the court's intervention in arbitration is usually at the beginning or the end. It's at the beginning when somebody wants to bring litigation proceedings where there's an arbitration clause. And it's at that stage applications are made at the court to stay the proceedings, or in the case I cited you, it's a foreign arbitration, sometimes an anti-suit injunction. During the course of the arbitration, certainly my experience is it's rare that the parties go off to the court. Often there are provisions that you need the agreement of the parties or the agreement of the tribunal. It delays things. The only time that it perhaps is critical, the main time it's critical, is if somebody wants to challenge the jurisdiction before waiting until the end of the arbitration award. Then the courts come in again at the end when applications are made in the court of the seat, either to set aside the award or to set aside the award or to allege that there's no jurisdiction. And then, of course, they also come in, but not necessarily in the court where the arbitration was heard, in the context of enforcement. So they slightly bookend the arbitration, but they're there in the middle to support the arbitration if something goes wrong.
Which is what I was wondering about in part because, as you were saying, the law of the seat is going to be very important as the arbitration goes forward. And I was thinking particularly about interim measures, if some sort of interim measure was necessary. There, surely you must, I mean, maybe the arbitrator just issues it, but wouldn't the court be the backstop?
Well, the court is the backstop, but tribunals like to try to avoid invoking the courts. I mean, in England, you can give peremptory orders and then it can go off to the courts, or parties can agree if there's a legal issue they want resolved by the courts and the tribunal agrees, that can go off to the courts. But the courts are involved, certainly in my experience, relatively infrequently during the course of the arbitration. They're there as an insurance policy, and occasionally they're needed. But most tribunals try to deal with the issues going along themselves. Their sanctions are limited, and this is one of the problems. They've only got cost sanctions, or people say, well, you're going to aggravate the tribunal. I'm not sure how much notice people take of that. But there are things that tribunals can do if people don't comply. But ultimately, the courts are there as an insurance policy if needed. And as I said, otherwise, their involvement tends to be more at the beginning and the end, but not exclusively.
Might I add just one American wrinkle? And I call it American wrinkle because it is something that's really unique to the U.S. There's something called the 1782 proceeding, which allows you to get evidence for use in a foreign proceeding. And so this provision has caused a lot of troubles in U.S. jurisprudence in recent years because the question was, well, is a foreign commercial arbitration a proceeding within the meaning of Section 1782? Is a foreign investor-state arbitration a proceeding within the meaning of 1782? So do you want to?
Go ahead.
Oh, no, I think we're probably thinking the same things, but that's another way in which U.S. courts can get involved, although usually you have one of the parties to the arbitration being the party that is seeking the evidence through a 1782 proceeding. So it's not necessarily directly the arbitral tribunal, but it is another way in which litigation is very important sometimes to the conduct of foreign proceedings.
Yeah, Judge, the only thing I was going to say is there's a further American wrinkle. I totally agree with that sentiment, which is Section 7 of the Federal Arbitration Act. So worth recalling, the United States in its infinite wisdom decided to regulate arbitration in 1925 and didn't really go back and revisit the issue again, except when it ratified these two treaties. And so a lot of the statutory framework that even applies in international arbitration to the extent the ratifying legislation of the New York Convention and the Panama Convention don't address the issue are nonetheless brought into international arbitration through a provision of the implementing legislation called the Residual Application Clause. So Section 7. Section 7 basically says that if Jessica is my arbitrator and somebody has within the United States has evidence that could be of use in our U.S.-sided arbitration, that I could ask Jessica to issue a subpoena under Section 7. And about 3 or 4 years ago, a decision was handed down that sort of tests the boundaries of Section 7. It actually involved a U.S.-based law firm, but essentially the model was you had an arbitration that was cited in Forum A. And as is often the case, given the procedural flexibility of arbitration, the parties asked the arbitrator to temporarily sit in Site B because there was some convenience to the parties of that site for the hearing. Well, unbeknownst to one of the parties, Site B was also the locus of a third party that the counterpart in the arbitration wanted the information for. So the minute the arbitrator sat in the temporary locus, that party asked the arbitrator to issue a Section 7 subpoena in that locus, even though it wasn't the arbitral seat. But because it was a temporary locus that was permitted under the arbitral rules, the Section 7 power was upheld. And so I think that's exactly right, that the general norm certainly is, as Judge Wood said, you're sort of getting to arbitration to get out of court, resolve these things expeditiously, but you keep seeing these forms of judicial assistance creep their way back in, not only at the front end and the back end, as Hilary said, but depending on the wrinkles of the particular jurisdiction, quite often in the interstices of the dispute.
So I have one broad question for the panel, and then I'll turn to questions from the floor. The broad thing is that all day today until this panel, we've talked about sort of more public law things, tensions between the United States and China, or how are we, what's going on with the European Union and ourselves, et cetera. And yet, arbitration really happens, people have business dealings all over the place. As Hilary said, there are 150 some odd countries that are parties to the New York Convention, a few more are parties to the Panama Convention. Is this kind of private ordering with contracts kind of the way to keep international commercial relations moving along smoothly despite these geopolitical tensions?
So I'm so glad you asked this question, because I think I would answer it in two different ways, and to sort of as a nod to Michael and I think some of the principles underpinning this forum. I think all of you could sort of look at Judge Wood's question as this being a battleground between freedom and sovereignty. Now, what do I mean by that? So on the one hand, I think with the decline of the non-arbitrability doctrine and the fact that more and more traditional public law disputes could get resolved in arbitration, that seems to have gone pretty well, right? I mean, Mitsubishi tells us, in the event the arbitrator truly goes off the reservation, we reserve the right to refuse to enforce the award under Article 5.2b of the New York Convention. But the reality is that happens pretty rarely, right? So if we're focusing on this tension between the freedom to where to resolve your public law dispute and the sovereign's interest in that private ordering, that seems to have gone well. Now I want you all to focus on the particular mode that Jessica was talking about, because that's a very different tension between freedom and sovereignty. It's not the public interest in the claim, but it's the sovereign's interest in being a commercial actor, right? It's essentially the confluence of the rise of the restrictive theory of sovereign immunity, along with the replacement of the espousal system of public law claims into the private ordering that Jessica talked about. And there, I think you've seen a great deal more friction, whether it be denunciations of ICSID, withdrawals, these sort of clamorings for greater transparency, the sort of the throwing up of the hands when a percentage of your GDP gets set aside in an award. And I think relative to the private resolution of the public claim, the public resolution of the public actor, the jury's still out on whether or not that's the best way to sort of ventilate the broad question you described. That's my view.
Hilary, Jessica?
I'll keep my answer short. I mean, as an international arbitration practitioner, I'd say yes, it's the way of the future. From a practical perspective, I think that the system of ISDS is very much under attack right now. I will not belabor the point about the EU, but I'm sure many people in the room know the EU in particular has been fighting very hard against the idea of intra-EU arbitration of investor-state disputes. So I think there's a lot of pushback right now against the system, but I honestly cannot think of an alternative right now that can be truly fair and better.
So and am I right? USMCA also excludes it, yeah.
Yeah, exactly. Well, actually, there's a small carve-out for Canada, Mexico disputes, but the US has completely extricated itself from it, yes. So, there is a lot of pushback, a lot of change to the system, but I think we need to work harder at improving the system rather than saying it doesn't work and we should just put it to the side and ignore it. So I do think it's the way of the future, especially private commercial arbitration. But even investor state, I would say, still has a future.
And just to add on international commercial arbitration, I mean, I think there are two factors which have, well, there are several, but two in particular have given rise to its exponential growth. One, of course, is the New York Convention, which, although not entirely, largely removes the difficulty of enforcing the awards compared with judgments. And the second is parties do not like being subjected to the national court of their own courts necessarily, but certainly not to the courts of their other party in a contract. And arbitration gives them the opportunity to choose a neutral seat where their disputes can be resolved. And I think those two factors in particular are very attractive in the context of international trade. And so I agree that it's going to continue to grow. I mean, we'll always have litigation, but arbitration, I think, is an increasing force.
Comments, questions from the audience? All right. The first person I see is at microphone to my left.
I won. Is this on?
I'll go back and forth.
Thank you for a fantastically interesting panel. I have a quick question for Hilary, and maybe you began to answer it at the end, but in this, everything makes my head hurt in this space. Roughly what share of these complicated cases are essentially reflecting that the contracting actors don't understand all those complexities, and they wind up in those difficult cases because nobody even knew this was going to happen, as opposed to at least one of the parties gaming it to some degree? Okay.
Well, I don't think there's any hard and fast answer. I think one of the problems you get difficult issues is because the arbitration clause is usually put in right at the end of lengthy negotiations in complex contractual agreements, and often by transactional lawyers who don't fully understand arbitration, and so they go wrong. And it's when then, I mean, there are very simple formulas that they can set out which would avoid these problems. Unfortunately, or perhaps fortunately for those involved in dispute resolution, they don't always do it. But that's really what happens. So the complexities arise, usually, not exclusively, because something's gone wrong with the arbitration clause or the wording of how the arbitration is to work.
Can I abuse it? I meant to say I have two questions to pose. And my question for Bo is, what the hell with your maps of the states? I mean, and I'll be talking tomorrow. I've been now working for years looking for these surprising fragmentation across the US states and how this contrasts to things in Europe that in some ways are sort of cleaner or have been dealt with in terms of sort of having a single market. But I didn't know about much of this stuff. And now, okay, I get the context of American federalism and that actually, what you're showing is, as you were suggesting, sort of characteristic of American fragmentation in all sorts of ways. But the what the hell question is business. I mean, we have a uniform commercial code. Like one of the things that is often upheld as an exception to that is we have a uniform commercial code. People talk about one of the things that makes for a more single market in the United States effectively relative to Europe is bankruptcy. Solvency is more similar than in the United States than it is across European countries, which is a real problem. Just stands out as something like if you were going to have business pressure for more rationalization of the system, wouldn't this jump out? And can you tell us anything about, is such pressure there and the institutional system is resistant to it, or does nobody ask for it? It's just not a conversation?
So I'll give you a partial answer, and I may actually invite our moderator, just given her role not only as somebody whose opinions on international litigation I've really admired, but given the role the ALI's played in the space. So two partial answers. I think partial answer one, for a period of time, you had this odd divergence where you had a foreign commerce clause on the one hand, but you didn't have courts of general federal jurisdiction on the other hand. And so as a consequence, the evolution of a lot of these principles was occurring against the backdrop of state judicial jurisdiction. The second thing that I think you had happen was you had sort of the Erie Revolution. And so as a consequence, there was this sort of marker that gets put down in 1938 that these swaths of law are no longer the domain of, quote, general federal common law. And ever since then, there's been this tension about the extent to which, I mean, going back to the very first panel, the efforts at building a coherent national framework for interstate, international commerce tread upon federalism. I think it's part of the reason why you saw a decade-plus delay between the adoption of the New York Convention and the ratification of it in the United States. It's part of the reason why you saw this sort of tension ever since Erie with these little gaps of federal common law, Bank-Keck, Sabatino. But on the other hand, Sompertex basically says, well, we don't really care what Hilton versus Guillot said in the pre-Erie era. We're stuck as a federal court sitting in diversity, applying the state foreign judgment law of us. And so every now and then, the ALI undertakes a project. There's an effort to try to develop a restatement, a model statute. But I think some of it is just some residual resistance of federalism.
And I'll be very quick. I'll just give you one pragmatic reason. The states are very jealous of their own prerogatives, and the kind of debate you'll have, say, for a statute on recognition and enforcement of foreign judgments, is you'll see this body called the Uniform Law Commissioners, who consider this their bailiwick, and they're the ones who gave us the Uniform Commercial Code, one of their great successes. But there are all sorts of other uniform laws floating around there, including, as you saw, a couple of different versions of recognition enforcement. So there's this other political layer that is getting in the way of a national solution. Let me go to the person over here.
I had a question and a half for Jessica. So I understand that India is sort of letting its bits roll off and that Ecuador is getting out of the bits. I guess I wondered if investor-state arbitration is a victim of its own success as there become more and more bigger and bigger judgments that developing countries find things less and less useful. I also wondered if the definition of investor is too broad. I've heard a critique of ISA that says that companies can sue, but also investors in those companies could bring claims, and sometimes they may have different interests, possibly opposing interests. And I wondered what you thought of that as a practitioner.
Sure, absolutely. So, I mean, with respect to your first question, I think absolutely the answer is yes. Very much a victim of its own success. I'll say in this context also, I think what we've learned over time is a lot of countries did not really understand what they were signing up for when they first signed these treaties. And I'll give a concrete example of somebody I know from a country I will not name, who used to negotiate these treaties. And we were in a course together about umbrella clauses, actually, which I discussed earlier. And we walk out of the room and he says, "Did you understand any of that?" And I'm like, well, wait a moment. You have multiple treaties that you yourself negotiated with protections, including the umbrella clause. So I think very much when this system of BITs started, people did not fully understand the power they could wield with those BITs. And also, frankly, the powers that they gave private individuals and corporations to go after governments, oftentimes for very legitimate claims, but that governments otherwise would never have to see or face, right? Because there just is no forum. And then with respect to the second part of the question, I'm sorry, I've now forgotten it in my passion about the first one. Investor definition, thank you. I mean, I think it's hard, it's tough because that is another thing that is squarely within the state's right to basically put in the treaty, right? The only thing you need in these treaties is agreement with your contracting counterparty. And so it's up to the states to define the term investor as narrowly or as broadly as they want. I think in a lot of the earlier generations of BITs, and by now people sort of recognize there's at least 3 generations, in the very early generations, it's an extremely broad protection. But if you look at the more modern BITs, there's a lot more circumscribed definitions. Now, it is true, minority investors can bring claims and the majority investors can bring claims. They can bring the same claims, but in different arbitration proceedings, and there are instances in which that has been done, and tribunals have reached different results. So it's definitely something that I think the arbitration community needs to work on more, figuring out what the right balance is.
All right, I'm afraid we are out of time. I think we'll have to ask for the rest of you to pose your questions in the hall, but it's been a great discussion. Please join me in thanking the panel.